That's really not in my zone, but it's something that's been neglected for a while. So,
You're right. And looking at our city and our surrounding towns around us, how would you describe the mood of Daytona Beach?
I,
Kind of a subjective question, but
yeah,
how would you describe our
I
mood?
think most of the residents are happy the way we're, going with the progress. I mean, maybe not always happy with all the people that are moving here. I mean, daily, where we have 1,000 people moving to Florida daily or 1,500. But otherwise, I mean, there's always going to be changes. I mean, we can't stay the way we were.
Yeah.
I mean, and it's hard to explain to residents. A lot of these projects they see has been in the works for many, many years, and you just can't go back and but we have people moving here, so we have to supply a place for them to live as
Yeah.
well. So,
And you're quite busy.
yes, I am.
Being a commissioner is not the only thing that you're involved in. So how do you kind of balance the public life that you have as a commissioner with all the other private activities that go on in your life?
Well, one thing that's good about me, I'm semi-retired
Mhm.
now. So, time management, and my kids are grown. I do have 13 grandkids and a husband, but they're used to me. I've always been a workaholic. So,
Okay.
and they'll tell you, and I actually have a daughter that's doing the same thing, and I'm like, slow down. But I love working. I love helping people. So, and I think I manage it very well with family
Mm.
and
Okay, I'm going to call to order this special magistrate proceeding this 12th day of April, 2024. And I believe we're here on the matter of City of Daytona Beach versus Ivan and Carden LLC, and specifically with regard to a notice of violation dated March 2024. Will all those representatives for the City of Daytona Beach will be testifying at this proceeding? Please
Mr.
stand
Judge,
and
I'm
be
not
sworn.
sure whether we have someone for Tran.
It should be
Oh.
on Zoom.
Should be on. I'm sorry, I didn't understand you.
There's no one via Zoom.
No one there.
Okay,
No one has joined the meeting, correct?
okay.
Just, no, they were sent the link. They were noticed.
Okay.
Mhm.
The
Yeah,
council-
and the representative was here last time. In February. And we've been in contact. He should have been here.
Okay.
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? I do. Thank you.
Okay, I presume we are here on case number SMG 042480. That having been said, is there anyone here for the respondent, Ivan and Carden LLC? Okay. Is there anyone else having any interest in this matter wanting to be heard? If you would please state your names and identify your parties you're here on behalf of.
Mr. Vagovic said he is on.
Pardon?
Mr. Vagovic did say he is on.
Okay. Let's get all our appearances, and then I'll ask the city to make their presentation.
Judge Michael Lambert, I'm here on behalf of the Social Company.
Social Club, Inc.,
Is the tenant.
Social Daytona, Inc. All right, do we have anyone appearing via Zoom?
There's no one in the meeting, Your Honor. No, via Zoom.
Okay. All right, how many matters do I have before me right now?
There are two.
All right, that is SMG 04-2480. And SMG 04-24-81. Have I said that correctly?
0424, that's it. Yes.
Okay. Do we have the same respondents for both?
The property owner is only on SMG 042481. The
No.
property owner and the tenant
Go on.
are on SMG 042480.
All right. Then how should we address these if it matters?
Well, right now, Mr. Lambert, Brian Lambert, just showed me a screenshot where where the counsel for property owner is showing that he's on Zoom, at least from that screenshot. So I'm not sure where the confusion is, but he believes he's on, and I don't know how we can resolve that. Ask our IT if there's something we can do.
Yeah, they had chink.
We're going to create another Zoom link and send it to him to see if that, to mitigate technical difficulties that apparently we're experiencing back here. So just give us a moment.
All right, real,
He is the one that's on both cases.
okay, take your time, we can wait. Is there anyone appearing by Zoom?
Good afternoon, Your Honor. Kevin Vagovic appearing on behalf of Tammy Tran. I apologize for the delay. I guess we had a different Zoom link that my client and I were waiting in there for about 20 minutes. So I apologize for the delay.
No problem. Are you the only one appearing?
My client should be here. She received the same email I did, and there she is.
All right, if she's going to be testifying, we need to have her sworn. Is she going to be testifying?
I believe so, Your Honor. Yeah, she'll have some things to say.
All right.
State your name. I can't hear you.
Is it Ms. Tran?
She's got to turn on her mic.
He's muted, correct. Please unmute your microphone.
Tammy Tran.
Raise your right hand. You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes,
Thank you.
thank you.
All right, Mr. Inspector, which case are we proceeding on first?
SMG 042480,
Case number one.
case number 1.
All right, I have a notice of violation. And what is the relief the city is looking for?
We're looking for a irreversible, irreparable fine of $15,000, both the property owner and the tenant.
All right. Am I to presume we have a will fine in place, consequently we can dispense with the need for the finding of compliance or non-compliance?
In this situation, you previously made a finding that these violations, the nature of the violations were irreparable and irreversible in nature based upon pursuant to Chapter 162, 162.09, 1D of the Florida statute, which basically would represent that the acts that were done are acts that can't be reversed in terms of its economic benefits that occurred at the time that the violation occurred, and it can't be undone, as well as the impact or effects of the actions that were taken or were done in such a way that they can't be now undone without and can't undo the effects that have occurred. And so, based on the prior ruling of that being deemed irreparable and irreversible, we come again with that same determination. So it's not really necessary for it to also be recognized as a repeat violation. But yes, indeed, it would be a repeat violation, which would, through the repeat violation process, the maximum fine is $10,000. Through the irreparable, irreversible, it's $15,000. We are proceeding under the request that it be deemed irreparable and irreversible in nature, and that a $15,000 fine be considered by the magistrate, and that will be based upon the evidence that we will present to show the egregiousness of the gravity of the violation and the efforts of the respondent to come into compliance.
Okay, well then, before we go into the evidence and any substantive determinations, does the respondent, any of the respondents, want to be heard as to the procedural posture of the matter before we get into the testimony? In other words, it sounds like we previously found the respondents in noncompliance. We previously made a determination that there was a violation. If I'm not mistaken, we previously fined both respondents. I don't want to characterize this as a repeat violation because counselor indicates it may be something different than that. That's all I'll say. So does anyone but want to be heard procedurally on where we stand before we get into it?
The only issue from the social Daytona is that they were not provided notice that particular hearing, so they were not here for that.
Have we not heard that already?
I'm sorry.
February hearing. The February hearing is the hearing in which we fine them $15,000? Okay. All right, well, let's back up and, Mr. City Attorney, just tell me what you want me to do.
Yes, they were noticed for that hearing. They weren't present, but they were noticed, and I would look to the secretary for the magistrate to provide the assurance that they had been noticed for that proceeding. I think we confirmed that they were noticed at the time, and I'm sure we can provide that notice, that proof of
You're
the notice.
satisfied they were notified, that's on you, so,
Yeah, we're satisfied.
okay, then we'll move on. Then-
Your Honor, if I may, regarding the hearing that was set for this past Wednesday, I think it was what, the 9th, we were never, I was never noticed for that. My client, they sent certified mail to her address out in Texas, but from what I see in the file, it was returned as non-delivered and not able to be found. So, and my office was never given any notice either of the hearing on the 9th.
Okay, anybody else want to say anything on the record before we move on? Okay, all right, what are we here on today?
Okay, I'll turn this over to the code inspector. We're here on a set of violations related to just what's indicated here. Oh, it's right here on the agenda. One violation we're looking at. We're specifically speaking as to case 1. So, as to that case, the violation is a violation of Article 10, Section 10.2(b)(2) of the City's Land Development Code, occupying or using land or structure without first obtaining all appropriate development permits. And the city's allegations is that the property is being used and has been used and continues to be used on a regular basis for unlawful sale of alcohol and being operated in essence by all definition pursuant to the evidence that will be presented as a nightclub, which would be completely in violation of the elements of this and requirements of this code. And so with that being said, that is the reason why we're here on this violation. This would be a violation from our perspective that would have required actions both of the owner in terms of granting these authorities and the tenant in terms of the actions of actually occupying and using the facility.
Okay, what are the appropriate development permits, just for my edification, that the property owner and/or the tenant are supposed to have, that they don't have, that exposes them to whatever liability you're about to present?
Rather than me talking
Just
over...
explain the title to me.
Yeah, so I was going to say, rather than me talking on the general surface, which is, the general surface is that they have to have things like, if they're going to be selling alcohol, they have to have alcohol license, they have to have site plans, they have to have approvals from the various divisions of the city, which they did not have.
Okay,
And so it had
those
no
are the
basis.
development,
Yes, and
the
I
term development permits is just throwing me off here.
understand, and I have...
I know there's an explanation, I just haven't heard it articulated.
Yeah, I have Ms. Askew here to testify or speak to those because she would be the best
Okay, that's fine.
member of the city to speak
All
to
right,
that
well,
issue.
whoever's going to speak, you can explain that to me along the way. All right, go ahead.
So why don't at least have Ms. Askew speak to that,
That's
just
fine.
for information purposes.
Go right ahead.
We can go on from there, so that you can just advise some of answering those questions.
Good afternoon.
Good afternoon.
The way our process works with
Then who you are,
Rose Askew, project manager for the city. When applicants come in for businesses, based on the type of use that they ask for, there's a process to develop the site to determine if it's acceptable or if things are needed for that site, and also to determine whether or not the use is allowed. And so we have what's called the technical review team that they come in and they meet with, and the technical review team will tell them, based on what they're asking for, if the use is allowed or if it's not. If it's not allowed, this is the process you have to go through. If it is allowed, this is the process. So for instance, for the hookah, because my understanding is they have been doing hookah as well, there's a very specific type of ventilation system that's required that has to be installed on the property before you can start to do that. In addition to that, having your tobacco license from the state of Florida. For alcohol, if you're serving alcohol, you have to have your license from the state of Florida prior to being able to do that. But in addition to that, you have to develop the site to determine whether or not you meet parking, landscaping, all different types of development criteria for that use to be there. And none of that was actually done for this business, and it still has not been done as of today. None of those things have been met.
So bottom line, we're talking about what? they've got an unpermitted bar that they're operating?
That is correct, yes, sir. And
I
it's
don't mean to be
operating more like
crude,
an,
but I'm just trying to understand.
that's correct. It's operating more like a bar or a nightclub, more so than a social club. Social and private clubs are more like an Elks Lodge.
Okay.
They're operating like a nightclub or a bar, which has never been approved. I looked at all of the documents. They came in as a not-for-profit, and it's not operating as a not-for-profit. It's operating like a nightclub or a bar, which absolutely has not been looked at or reviewed by anyone in the city.
Very good. Thank you.
You're welcome.
Hang on a second. Any attorneys have any questions for Ms. Askew before we excuse her? Doesn't look like it. Okay.
A real quick one.
All right.
Have you personally been to the 631 Grandview?
No, sir, I have not.
So everything you're saying about them doing this and doing that is based upon what somebody else has told you?
Correct. It's based on my conversations with the police department and code enforcement and photos that I've seen of activities that have occurred at the site.
Your familiarity with the
Yes, sir.
city's
With the
ordinances,
city's ordinances.
regulations.
Yes, sir. I am the
And
staff
your-
person with the city that does our land development code regulation.
And I would presume you've also looked to see if they had any permits that would have governed and found none.
Yes, sir, that is correct. And Kim Flaherty is here from Permits and License. She will also testify that those permits have not been pulled.
Okay, very good. Thank you.
Thank you.
I have a few questions, Your Honor, if I may. Ma'am, have you ever spoken to my client, Tammy Tran?
I'm sorry, can you say that again?
Yes, ma'am. Have you ever spoken to my client, Tammy Tran, who's the landowner?
No, sir, I have not.
Okay. With regards to getting these permits for alcohol and tobacco to be utilized or sold on the for consumption on the premises, who would be the party responsible for pulling that permit?
The business owner.
The business owner? Okay. And what about all the, okay, thank you.
You're welcome.
Hey, ma'am, I'm sorry, one more thing. Do you know the business owner? What business are you referring to?
What is it, Daytona Social LLC, whomever the business that has the license to operate on that property as a social club. That's who would have been responsible for that.
Thank you, ma'am. I have no further questions, Your Honor. Thank you.
Can I ask one question in relation to that?
Yes, sir.
Is there any obligation of the owner at all?
Yes, there is.
And what is,
Regardless of whether the property is leased or not, she owns it, so the ultimate responsibility for making sure that it's developed and operating in the manner that is required by the city, that is the responsibility of the property owner.
and is there
So-
something that they sign or in terms of obtaining whatever they have to obtain?
When you say they, you mean?
The owner has to give some type of authorization or authority to the,
That is correct. The owner would have to give the tenant authorization to make those type of repairs and changes on the property, and she would have to authorize that use, but she could not do that until the city told him it was allowed to be there.
Very good. Thank you. Okay, what's next?
I'm gonna turn it over. Your Honor, I'll just call our inspector to go ahead and tell what happened with this inspection and we'll look to the officer. I think he just wants to introduce the case formally.
Yes. Mark Jones, Code Compliance Field Supervisor. This case was field generated for violation of the City Land Development Code for occupying or using a land or structure without obtaining the appropriate development permits for this business. This business is acting as a nightclub without approval. This same violation was before the special magistrate on February 13th, and the property owner was fined $1,000 and the tenant was fined $15,000, as this violation is irreversible, irreparable. There is documented evidence that since that hearing on February 13th, the business was charging a cover charge for $50 per person. That included alcohol, beverages, and hookah. This took place on March 9th, 2024 at 3:15 a.m.
All right, it happened when now?
March 9th, 2024 at 3:15 a.m. I've had no contact from the property owner, and there is officers here that can speak to these violations.
So the officers are going to provide the testimony regarding the conduct complained of.
Correct.
You're giving me an overview.
Yes, sir.
Are you done?
Yes, sir.
Do you have any questions?
Not about the overview, Judge.
Mr. Vagovic, do you have any questions of Inspector Jones?
No, sir.
Okay, thank you.
Thank you.
Call your next witness.
Judge, do you operate by imposing the rule of sequestration for witnesses?
Okay,
There's no formal rule of sequestration, but that would obviously.
where are we gonna send them? It's piped into the lobby,
Oh, it is?
I believe so.
Okay.
Rule of sequestration, interesting, okay, well,
Well, it's public to the whole world right now. I mean, that's why
Yeah,
we're
I mean-
compelled to make it a public meeting.
okay, I think I'm gonna say no to that one. I don't know how I'd do it if I wanted to.
And we would just call the officer.
How many witnesses do you have?
As far as substantial witness in terms of the material would be Officer Lieutenant Gurnett. I may bring up one other employee that would be Kim Flaherty, who would just speak to the prior question.
Okay.
That's the question of the contact with the owner.
And how many witnesses do y'all anticipate calling?
Oh, Judge, probably 3.
Okay, all right, let's go. First witness.
And possibly even one more, Sergeant Lowers.
First witness.
Okay, it will be Lieutenant Gurnett.
My name is Kim Gernert. I'm a lieutenant with Daytona Beach Police Department. Been there 21 years. As I testified previously in the hearing in February, that we have executed several undercover operations within the business purchasing alcohol. Subsequent to the purchases of alcohol, we've then executed a search warrant. We've executed a search warrant in September, January, February, and in March, and in each search warrant, we have recovered alcohol. There was only one time where we recovered alcohol that we did not arrest the occupants of the business. After our hearing in February, we executed a search warrant after conducting an alcohol purchase. Each time we've done this, we've done it with recording devices, cell phone with video recording. In the search warrant and the undercover operation in March, on March 9th, undercover detectives went into the business. They were charged $50 cover fee, which also included their alcohol. One detective ordered vodka and orange juice. The other ordered cranberry and vodka. And both drank the alcohol, recognized it to be alcohol. They were ordered to come out of the business, at which time we executed the search warrant. They don't keep bottles of alcohol on property anymore. They're actually mixing it in with common drinks like Sunny Delight or cranberry juice. They're mixing it in the bottles now, and that's how they're keeping it in a cooler. Since that hearing in February, they've been open at least Fridays and Saturdays, sometimes well into 6 a.m. They generally don't really open until after 12:30, maybe 1 o'clock in the morning. When the clubs on Seabreeze general area over there, when those clubs end at 2 a.m., an influx of people come to their business. Without going in myself to see exactly what's happening every single night, my assumption is that they are in there selling alcohol and smoking hookah. We've been in there many times where we found they have a room where they keep their hookah, where they keep the glass pipes and the tobacco in there. They do have a tobacco license, but not one registered owner of that business has a liquor license, and that is per alcohol, beverage, and tobacco. They still don't have what they need to operate as a bar, club, social club, however they want to call themselves.
Okay, Mr. City Attorney, what are their licensed permitted uses and hours of operation?
Again, I would,
What are they allowed to do? Before I jump too much further into what they're not allowed to do.
again, I would look to bringing up again, Ms. Askew to speak to that, or, Ms. Askew would be the best one to speak to
Okay,
what's permitted and not permitted as
that's
comes
fine.
on.
Officer, if I could just ask you to step aside, and then we'll come back to you. Ms. Askew? Okay, I've got an owner and I've got a tenant. I don't know if it makes a difference. I don't know if there's a list of rules as to what the owner's allowed to do and a separate list of rules as to what the tenant's allowed to do. But I'm looking for somebody to educate me as to what they are licensed for, what they are permitted to do. What would that be?
So the owner gave them authorization to operate a social club. That, in our land development code, that falls under a private club or lodge. They're a not-for-profit private club or lodge, and they're supposed to operate like an Elks Lodge, just Kiwanis Club, those types of things. They're not supposed to operate where they have alcohol, where they have charges to come in. None of that stuff is allowed. So it's only supposed to be like a private club or lodge, where if you went to a lodge, you can only have your members there. Your members can invite maybe a guest, but it's not supposed to be where everybody and anybody can come in and you're charging $50 to get in. That's a nightclub.
Okay, what are
So
their
that's all
hours
they're
of
authorized.
operation?
If you don't have alcohol, the city doesn't have, if you're not serving and selling alcohol, I need to say that because they are doing that.
But they're not
Then-
allowed to.
That's correct.
Okay.
So for normally a business that doesn't have an alcohol license, serve or sell alcohol, there's not a time when you have to close. If you're serving and selling alcohol, you are required to close at midnight unless you have an extended hours permit approved through the city, which will then allow you to operate up till 2 a.m. But under no circumstances can you be open past that with alcohol.
All right, and what does the hookah component add or subtract to this scenario?
There's some additional specific criteria in the Code of Ordinances for hookah establishments. And in addition to that, hookah establishments are still supposed to close at midnight.
Okay. Are they supposed to be licensed for that?
Yes, they would have to have a business license for hookah, and they'd have to have the state of Florida tobacco license, which is what she's saying they have in order to have the hookah. But this particular property, they were only approved to be like a private club or lodge. So they're not approved for either the nightclub use or the hookah use.
Okay, thank you.
You're welcome.
All right, officer.
If I may throw one more thing out there, every single time we've conducted one of these investigations where I've sent in an undercover officer, at no time have they ever asked the detective or officer if they want to be a member and sign a form or agreement form or pay any form of membership fee. The word membership has never been said to them. They've actually sold alcohol to a 19-year-old. We have a 19-year-old officer in our department. I sent her in there. They actually sold her the alcohol, even though she presented her driver's license, her actual driver's license, showing that she wasn't close to 21. But I've had conversations with the owners many times, and they do say that they are a social club with memberships. Random people come in. If they're at no time ever saying membership to anyone that comes to the front of the business. When I've executed search warrants, I've found their social Daytona stamp like you would get if you went to Razzles or 509. In the last one I executed in March, they actually stamped the hands of the officers with their social Daytona stamp.
Okay. Mr. Vagovic, any questions?
Yes, sir. Thank you very much. Good afternoon, Lieutenant.
Hi.
Have you ever spoken to my client, Tammy Tran, who is the property owner?
No, sir.
Okay. Is it safe to assume that you said September, January, February, March, that you executed search warrant? Was my client ever present during any of those searches?
No.
And do you know whether she was notified subsequent of what happened?
No. I have no idea.
And just curiosity, you said that, am I correct that you said that the owners were arrested before?
Yes.
Okay. Have they been formally charged with anything?
Yes. Oh, with the state attorney's office, I don't know.
Okay, but
Their prior arrests are, I think, still in the process with the state attorney's office.
But it's all stemming to the searches and the selling underage, selling to an underage, all these things that we're talking about today.
Yes.
Okay, thank you, Lieutenant. I have no further questions. Thank you.
Mr. Lambert, do you have any questions?
Lieutenant, everything you talked about with regard to people going in there, making certain purchases, you were not present for.
No, other than when I executed the undercover operations with the phone.
And the officers that go in there, even though they're undercover, do they, like a confidential informant, wear any recording devices?
They are, yes,
Wouldn't that be the best evidence of what was said to them?
absolutely.
And how long have you been in law enforcement?
21 years.
And to you, what is evidence?
In this case was the recording of the undercover operation. Even though the officer, the undercover detective or officer goes in with this phone, on the other end, I'm able to watch what's happening and I can hear what's happening. So that's why I testified to the fact that they were never offered memberships.
But
Back
again,
up and say that again.
So every time I execute an undercover operation, whoever I send in there is equipped with a cell phone that records the situation. I can hear it. I have an app that works with that program on the phone that they're sent with. I watch the phone. I watched it through the app. It's like watching a camera. And I can hear what's being said and I can
Hearing
watch
it live.
Hearing it live.
Okay, thank you.
and when you served the search warrant, how far was that from when these undercover officers went in?
After asking them to leave, probably within 15, 20 minutes.
Okay. And when the officers went inside, I was looking at the receipt and inventory report, and there doesn't list any alcohol on them?
They're not on any, all the receipts have alcohol.
I'll ask Mr. Lambert, which dates are you
I would-
referencing when you say you're looking at?
Oh, I'm sorry. It's a copy of the search warrant.
From which
Are you asking me what I'm
This
searching
is
for?
related to the March, I'm sorry. Okay.
Right. No, I'm not asking what you're asking for. I'm asking for what you got.
We found alcohol within common jugs of beverages, like there was a Sunny Delight jug in the cooler, and that had alcohol in it.
Well, let me just go over that with you then.
Okay.
The evidence that you received, the inventory, was a Sunny Delight bottle of orange juice?
One of them was, yes.
Okay. Another one was an Ocean Spray cranberry juice?
Yes,
Another one, cranberry, also a cranberry juice?
yes. So if anything is open, any of those alcohol, anything that contained alcohol or was an open bottle, I can't tag it. I have to identify it by smell or taste, and then I have to dispose of it at the scene because I cannot tag it into evidence. Our rules don't allow us to tag liquid that's been opened. Now, if that jug was closed of Sunny Delight, I wouldn't take it because it doesn't have alcohol in it. As in, it had never been opened, I would not have taken it because it wouldn't have had alcohol inside.
Who did the smell test?
Myself and Sergeant Blowers.
And then based upon that, you poured everything out?
Correct.
And your reason then for destroying evidence is because you don't have any place to keep it?
We're not allowed to tag it, no.
Are you familiar with the destruction of evidence in cases?
That's not destruction under Florida Statute 562 because Florida Statute 562 gives law enforcement officers, we don't test it with like a test strip. The statute reads that you can identify it by smell or taste.
And in the form of objection, but more in the form of information, that's also provided in Article, Section 10-2 of the City Code in terms of identification and evidence of alcoholic beverage.
So Lieutenant, your confirmation of this being, or these bottles containing alcohol is your testimony?
Yes, I smelled the bottles, and if it smelled like it had alcohol in it, it was poured out on camera. Photographed beforehand and then poured out on scene.
And then were there photographs of these officers' purchases of alcohol?
No, it was on recording from the video evidence.
Okay, so there was a video of them doing it?
Correct.
Okay. And did you look at that?
I watched it live.
And what occurred?
They approached the front door,
Oh, no, I'm just,
Oh.
they're sitting,
They, when you walk in the front door, you either go left or right. To the left is their bar. At the bar, one of them ordered cranberry and vodka, the other ordered orange juice and vodka. They tried to pay, but their membership, or I guess I should say their cover charge included the alcohol with the $50. They were given the alcohol in a cup. They then sat in a particular area near the bar and were asked by Mr. Jacob to move because that was, I believe, a reserved area where they were sitting. So they then went to the right side of the business where they have a lot of couches and chairs, where they sat and drank the alcohol.
is there evidence on the video of a bottle being utilized to pour into the juice?
I don't believe so.
So neither of the officers would have been able to witness the use of a liquor bottle poured into
No,
a
because there
drink?
was no liquor bottles there.
Okay.
The alcohol was already pre-mixed.
So all that remains, or let me ask you this, did you keep those, the bottles that were taken?
Cannot. Our rules with the tagging of evidence do not allow us to keep that bottle.
Okay, so everything's destroyed?
It was
except
all
the
on-
officer's word?
Correct.
I don't have anything, brother.
Okay.
Now, a couple of related questions, Your Honor. Officer, you previously testified in another proceeding, and I'll ask this again. How long has this been going on with this business in terms of the investigations and sales?
So when the ordinance changed in April of 2023, we've gone there and informed them that the ordinance changed so that they had to fall into compliance. There were many code inspections of the business to see that they have a wall of liquor at that point. They were notified back then that they weren't allowed to have the alcohol without the permit, but this has been going on since April of 2023.
And approximately how many investigations, just approximately? I know you probably didn't sit down and count, so do you have something?
7.
Okay.
We've executed 4 search warrants. I've done at least 6, if not 7, undercover operations.
And these included, in some occasions, alcohol, beverage, and tobacco as well? I mean, the agents?
Yes, alcohol, beverage, and tobacco, State of Florida agency have assisted us with this as well.
Okay, and they've been actually there and cited?
Yes, the first time we executed a search warrant, alcohol, beverage, and tobacco was with us, and they're the ones that made the arrest for the sale of alcohol to the business owners and to this bartender at the time.
Okay, and you were here at the February hearings, right?
Yes, sir.
And wasn't Ms. Tran here at the online?
She was.
Okay, and so they were made aware that at that time, for certain, that there was not permitted, correct?
Correct.
Now, what's your knowledge of alcoholic beverage? Where the code basically says someone with knowledge of. Do you have knowledge of alcoholic beverage? You ever taste them or been around them or?
Sure.
So
I've been 21 once. I've had alcohol.
you know you recognize clearly
I recognize clearly the odor of alcoholic beverage, the odor of marijuana, the odor of tobacco being smoked. Yes.
But by policy, because the law allows it and allows it to be dumped or once recognized by someone with knowledge of an alcoholic beverage, they have a policy that you don't bring that in.
Correct. If the bottle has been opened, we cannot keep it. So when we executed the search warrant in September last year, we took in a lot of alcohol. I think I can't test. I would have to look at my notes, but we took in numerous cases of unopened cases of beer, numerous bottles of unopened liquor and wine. That was taken and tagged into evidence. There were several bottles that had already been opened at that time of vodka, of rum, and that was photographed just like I did in these subsequent search warrants where it was photographed and destroyed on scene because I cannot tag it because of being opened. Liquid, we cannot tag it per our policy.
Okay, in this March event that you speak of, the March investigation and ultimate arrest, what's the time of day or night or early morning when these things occurred?
I deployed the undercover detective and officer at 3:15 in the morning because the bars closed at 3 a.m. At that particular time since it was bike week. And about 20 minutes later was when I called them to come out. And then we went in with our violent crimes apprehension team and our crime suppression team to secure the business and detain the owners of the business. So well after 3 a.m.
I don't have any other question.
With regard to tobacco, when you served the search warrant the night?
Yes.
Tobacco?
There was tobacco, there were hookahs lit and live in the business on tables where customers would sit.
Are you someone who can use hookah and say that it's hookah?
I've never used hookah in my life, no.
Was anything taken to preserve that?
For the tobacco portion, no. The tobacco was not part of the search warrant. They have a legitimate tobacco license.
What about cannabis?
What about cannabis?
Yes, ma'am.
No one's allowed to,
Right, I mean, did you find it?
no,
What
not to
about-
my knowledge.
What about the stamp that says,
It has SD is what it says on the stamp. That was in plain view on the shelf, right next to a bowl, like a fish bowl where they keep their keys.
did you seize that to confirm your testimony?
No, it was photographed though.
Mr. McKeltry and Mr. Lambert, if I could just, for a moment, we're compelled to provide this as a public meeting, so if you can maybe speak up a lot.
This way.
The IT person is trying to make sure he have you on.
Okay.
Properly on the mic.
When it comes to the stamp, my reasoning for photographing the stamp was to prove that it's another characteristic of them operating as a bar or a nightclub. To seize that was not in my search warrant, so I did not seize it, but I did photograph it. It was in plain view.
And did you also search vehicles?
I did.
Did you locate any?
On the March 9th
No.
search warrant, no. And the
Okay.
February one, yes.
Or about March 9th? Able to find that, right? I don't have anything further.
Okay, did I hear you correctly that you've conducted 7 investigations at this location?
At least.
And on 4 of these occasions, you went to the extent of getting warrants?
Yes, sir.
And when we find have all of these investigations resulted in some sort of findings on your part of alcohol on the premises?
They were all positive for alcohol findings.
And what are the circumstances that cause you to go get a warrant as opposed to the other 3 occasions in which you didn't get a warrant?
Because the first two investigations where I sent in an undercover were to establish that the alcohol sales were occurring so that I could obtain a search warrant. The third one, there was a time frame where the 30 days to obtain a search warrant it was past that 30 days, so my information was considered stale. So I had to conduct another investigation of undercover alcohol purchases to then make my information fresh again to obtain a search warrant.
Okay. It would appear that if I'm wrong in my history, somebody can correct me. It would appear as though on February 26th, I entered an order fining both the owner and the business owner.
Yes, sir. The building owner, Ms. Tran, was fined for 2 instances of $500 each, and the Social Daytona was fined $15,000.
Okay. That's on February 24. On March 9, you're back in there
Correct,
with a warrant.
correct.
Any change in the operation between February 24 and March 9th that you could observe?
No, sir. They still operated exactly like they have for the last year.
That's all. Thank you. Got another witness?
If I could just ask one more question, and that's, was there any kind of business impact from the perspective, have you heard from the other businesses
Yes, I've actually serviced several complaints from several local businesses that they're very angry that they cannot operate past the 2 a.m. mark with their after-hours permit, or 3 a.m. if it happens to be a recognized event time frame like a bike week. I've spoken to businesses where their managers or their owners were very irritated. I've we received numerous anonymous complaints, probably from the business owners, that the business is in operation past 2 a.m. And that they are operating illegally.
Anything else?
I don't have anything else.
All right, we have another witness.
We'll call Officer Sergeant Blowers, Daytona Beach Police Department.
Sergeant Tim Blowers, Daytona Beach Police Department. I am the code enforcement liaison for the agency. I started back in approximately March. Since I've been the liaison.
March of?
2023.
Okay.
And I have been investigating this basically since then. When we talk about the drink containers and stuff, this is a photo of the alcohol and the drinks that they were mixed inside these kind of type containers.
When was that photo taken? Is that from the February event?
I believe so. I'd have to double check.
All right.
It was from case number 11198. No, that was January 12th one.
Okay.
But there are other ones. I personally called Tammy Tran and informed her of what was going on during the business hours and past the business hours.
You personally called her when?
It was back September.
Okay.
We notified her, hey, this is what's going on. You need to stop or do something to make them stop. She said she was going to evict them back then. Nothing occurred. That's really, it was, I've been there for the alcohol. There was many alcohol the first time, which we did tag, and then other ones that we were not able to tag.
When did you speak to Ms. Tran?
I don't have the exact date and time, but it was back in September
Oh,
23.
23.
And what did she tell you she was going to do in the way of any kind of remedial action?
She said she was going to file for an eviction on them, and she would forward me the paperwork, which she never did.
Okay. To your knowledge, has the owner done anything since then?
She has recently started an eviction process, but it has not finished.
Okay. All right, anything else? Mr. Vagovic, you have any questions for the officer?
Yes, sir. Thank you very much, Your Honor. Good afternoon, Sergeant. How are you doing today?
Good, sir. How are you doing?
I'm wonderful, thank you. You said you spoke to my client, Ms. Tran, in September. Have you spoken to her at all since then?
No, all the paperwork with the servings have identified that we've had problems with their continuing.
What do you mean by that, sir?
When she's been served for the code appearance cases, continuing
Yes.
to notify her via them.
Oh, okay. But you've not personally spoken to her since then?
No, sir.
Okay. Thank you. That's all I have, Sergeant. Thank you very much.
Mr. Lambert, do you have any questions of the officer?
Very quickly, Officer, you, excuse me, in the 9th of March case,
Yes, sir.
you did the police reports.
Yes, sir.
Is there any mention in the police reports that there was any alcohol on the premises?
It's in supplements.
When do you file a supplement?
It was the other officers that filed the supplement. I did the basic one, and then everyone else's supplements was then tagged into it with the photos, sir.
So at the time you wrote your report, you were unfamiliar that there was any alleged alcohol in the premises?
No, I was familiar that there was containers that contained alcohol there, sir.
Okay, and did you put that in your report?
Not in the 707 stuff. Just the basic of the buy and stuff.
By the time you did your report, had the search concluded?
Yes, sir.
I don't have anything further.
Okay. Mr. City Attorney, any questions?
No.
All right, next witness.
That's all we have for the red case as to this matter.
Okay. Mr. Vagovic, did you have any witnesses you wanted to proffer?
Yes, sir. I would like to call my client Tammy Tran, please.
Yes, sir.
Thank you, Your Honor. Ms. Tran, can you hear me okay?
Yes, I can hear you.
Okay, ma'am, when did you purchase this building?
In the beginning of 2023.
Okay. Go ahead, I'm sorry.
It's in January 2023.
Okay, and who did you purchase it from?
I forgot his name. But the realtors didn't know.
Okay. The lease agreement that's in place for this premises that you now own, were you an original lessor to the agreement, or did you just take the agreement over when you purchased it?
I just take the agreement over.
Okay. And have you ever met the tenants in person?
I met him back in during summer.
Okay. And do you own any part of their business, this Social Daytona?
No, sir.
You don't have any ownership interest? Okay. Are you aware, last time we were here in February, that we were discussing filing an eviction case?
Yes.
And have we filed that case since then?
Yes.
And do you know what stage we're in right now in the process?
We are at the stage where we have we need a court order and the hearing, waiting for the hearing.
Okay. And you still want to terminate their and evict them, correct? You still want them out of there?
Yes.
Did you ever have any contact with the City of Daytona Beach officials with regard to land development permits for the property?
Not after the last hearing.
But prior to that?
Yes. Oh, for the land development, I talked to Mark. I think Mark.
Okay.
Um,
Do you recall when that was, ma'am?
No, sorry.
Okay. Do you know, was this, I guess, when you purchased the building and you took over the lease, what was your idea or understanding of what the business operating there was supposed to be? Did the landlord ever tell you?
No.
Okay, so did you know it was supposed to be a nightclub or a social club or anything else?
From what the tenant told me, they told me it's a nonprofit and it's for social. Like, you know,
Okay.
they.
So, okay. And have you ever, did you ever have any discussions with the tenants about pulling the land development permits to do the build out that the city's claiming is required?
No, sorry. I just acknowledged that with Rose earlier.
Okay. Did anyone ever tell you that you need to get these permits for the development of the building?
No.
Okay. And as we sit here, do you have any personal knowledge? I guess the easier question is, ma'am, have you ever been to this Social Daytona Club, the building you own? Have you ever been there at night and seen how they're operating it?
Like I say, back in summer, when I don't see any customer there yet.
Okay.
It's pretty late.
Okay. Okay,
And I just stopped by there for like an hour, and then I left.
Okay, and are you still trying to do everything you can within your power to get these people, these tenants out of the building?
Correct.
Okay. Thank you, Your Honor. I have no further questions for this witness.
Mr. Lambert, any questions of Ms. Tran? Mr. Jackson, any questions of Ms. Tran?
Yes, yes, Your Honor. Ms. Tran, you only been to the business one time?
Correct.
Okay. Where do you live?
Texas.
Okay. And you've owned it for more than a year, correct?
Correct.
Yeah.
Correct. Today.
And you've had communication in the summer as well as in the fall about what's been going on, at least from the city's perspective at this business. Isn't that correct?
In fall, yes. I get in touch from the city Daytona in fall when I noticed it's like they selling alcohol without permit and they open late at night. And first is my knowledge in touch with the city is from the code enforcement with Steve. So I'll just try to fix outside what Steve required, the city required. Yeah, until later, I would say summer is when I, get to know Steve in touch and fix the building. And then around fall is when I know the issue is they operate the business without the license. They don't have the alcohol license, and they open like after midnight. Yeah.
Yeah. Ms. Tran, you do receive rental payments, right? They pay you to be there?
They pay me to be there?
Yes.
I'm sorry, I'm not
I mean,
clear
since the
with-
time, I'm sorry, since the time you've owned it, you've been receiving payments from them as rent. Isn't that correct?
Yes, I receive payment from them. Mhm.
When did y'all file the eviction? When was it filed with the court?
When is the last time I seeking out for Kevin, Mr. Vakovic? Yes, I seek for his help to do the eviction.
You remember what date that was?
Let me see.
So at some point, Mr. Valkovic will tell us, but nevertheless, do you remember which date it was?
In February.
But you don't remember which date?
Is he here? No, I don't
Okay.
remember the, sorry.
I don't have any other questions.
How much do the tenants pay you every month?
They pay me 2,000, at first, for last year, they paid me 2,600, 50, I would say, yeah, 2,650.
$2,600.50 per month?
No, $2,650 per month.
Okay. And is that what they're currently paying you per month?
They pay $2,775 a month now, but I haven't accepted their rent since February
Why is that?
because we asked them to leave, and then for all this cost that they did to the building, I would not want to keep them for all this thing they did. So that's why I filed the eviction. And I
And you or
stopped.
Mr. Vagovic can answer this. When was that filed?
Your Honor, it was filed on March 28th. I'm sorry, February 28th.
And who is it before?
It's before Judge Sanders, Your Honor.
And where does it stand at present?
We're trying to schedule our final hearing. Mr. Pappas came on for the tenants about 3.5 weeks ago. He filed his notice of appearance, so we're all in the process right now of scheduling the final hearing. I believe Mr. Pappas indicated that he had some kind of scheduling conflict. Obviously, though, we're entitled to summary procedure, so I'm going to try to get us a hearing within the next week or two.
When do you expect to be able to get a writ of possession?
Conservatively, Your Honor, I would say within a month. And I know that sounds like it's far out because it is, especially with summary procedure, but we've not been able to actually schedule the hearing yet. So I would hope within a month, Your Honor. I mean,
Who has appeared on behalf of the tenants in your eviction proceeding?
George Pappas, Your Honor.
And you say that just recently happened?
A couple weeks, March, he filed his March 19th. He filed his notice of appearance and answer.
So have the defendants been served,
Yes, Your Honor.
but they haven't formally appeared prior to Mr. Pappas appearing?
Correct, Your Honor.
What's the next, if any, hearing you have scheduled?
We are trying to schedule the final hearing for possession right now, Your Honor. So we go in there and have essentially our trial on count one for possession. That's what we're trying to schedule right now.
Okay, thank you.
Yes, sir. You're welcome.
And in the interim, they've been, I guess, paying into the registry. Is that?
Yes, I saw on the docket that they've put some money into the court registry.
Okay, any more witnesses?
No, sir. Thank you.
Any more witnesses, Mr. City
no, sir.
Attorney?
No, sir.
Mr. Lambert, did you want to call anybody?
Yes, Mr. Jacobs.
Good afternoon, Judge.
I'm sorry, could you scoot over to the microphone, please, and state your name for the record?
My name is Richard Jacob.
Richard
I'm the business owner of
Jacobs.
Social Daytona.
Raise your right hand. You swear or affirm testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Mr. Jacobs, you're one of,
Can I interrupt? I wasn't sure what he said. What about Daytona? I wasn't sure.
My name is Richard Jacob. I'm the owner of Social Daytona.
Oh, that's, okay. Owner.
Mr. Jacobs, are there any other owners of Social Daytona?
No, I do not.
When was it formulated or accepted by the Department of Corporations of the state?
In the month of May 2023.
And was it for the address on Seabreeze?
Yeah, 631 North Grand. Yes.
And was that the first time that you had rented that business?
I've been the tenant for this property from 2022 with the last landlord. I used to be a hookah lounge till March 2023. And the city passed an ordinance on April 4th, 2023, and we were asked to close, and we closed from April 4th, 2023 till June 14th to get all my permits, which the city has asked.
What, your corporation was formulated for what purpose?
For recreational and pleasure.
And,
Recreational what?
And pleasure.
and has it been altered or changed in any way?
Never.
And when did the issue with the city first surface?
When I started to approach the city project manager for the after-hour permit, seeking if we do really need an alcohol, the after-hour permits, they said you do not need an after-hour permit if you don't serve alcohol or sell alcohol in the property. Ever since that, we have had search warrants coming from month of September. We had a stock. What they have as an inventory is the stock that we had from the hookah lounge. Sergeant Blower has come into my property, to my business, and he did say, you should have it on your camera, that you can keep it on your shelf as long as you don't sell it. And we had a big letter describing over there on the wall, not for sale, decoration purpose. And that is what they got, what they claimed with a whole lot of alcohol on September 17th. That's the day we started to have the problem with the city of Daytona.
And has it gone on up until?
Till as we speak.
With regard to the incident on March 9th, 2023, were you present?
Yes, I was.
Were you familiar with the people that came into the bar that were undercover?
When they came in, they did give their ID. We take the membership. We do have the two undercovers ID. Yes, we did, and we did explain them that it's a members only. It's $50 is your membership fee. We do not have a hookah. We have a hookah license under Sun and Jack LLC. We changed our LLC to Social Data Incorporation. We do not hold a tobacco license. So the membership fee is what we charge as 50, and we have more than anything that we can show that what we are serving is not liquor. They came in, they did make the purchase, knowing that they are undercover. We do know that they had the camera, as what the lieutenant was saying. We did see the camera on their phone, and we did serve them what they have us, but it's not what they claim, it's an alcohol. We serve them, but not alcohol.
And do you charge when you serve them?
No, we don't.
And the serving of anybody in there for a drink, is it an alcoholic beverage?
It's not alcohol. It's not.
What is it?
It's a non-alcoholic, zero proof. It's more fermented than the liquor. If you go by the smell, you could smell it and see. I do have my the evidence over there. It does smell like liquor. Tequila smells like liquor, but there's no liquor in that, zero proof. And yes, we did serve what they have came to the bar and purchased, which is included in the membership.
I'm going to show you for now 2 bottles. And are these examples of what it is that is
Correct.
mixed?
Yes.
And do they have any alcohol in them at all?
0%. We still have everything what we have served each and every time the undercover has come in. And they can test it. There's no zero alcohol in it if you have a test kit. It smells like Fireball, it smells like tequila. That is what we just come up with a new business idea in this location, and these people don't want us there. That's what is happening, to be honest.
And you thought you would experiment with this without notifying anybody in advance?
We have emails sent out to the city of Daytona Beach asking if we do need an after-hour permit, that they keep coming back of us. And they replied very clearly in an email from the project manager stating that you guys do not need an after-hour permit as long as you don't serve alcohol. This is not alcohol. This is non-alcoholic beverage. We have always stayed in touch with the city.
And are you open after 3 a.m.?
We open on particular days when we have some events that people have already asked us, reserve the spot for. So we don't take more than 25 people or 30 people as what they claim to. We have like more than a large number of crowd coming in there after everybody
Aren't you
closes.
supposed to be closed at 3 or 2? I don't know. What time? What is your closing time?
We open at 11, we close at 2:30, 3, sometimes goes till 4, depends on the crowd.
How late are you allowed to remain open?
There is no justification that states that we have to close at so-and-so time.
And wasn't that explained to you by, one of the city personnel?
Yes. It is very clearly explained.
I don't know if you want to smell this stuff.
Sure.
That one there is a Fireball?
It's cinnamon whiskey, but it smells like Fireball. Tequila smells like whiskey, all these things.
There you
I
go.
don't want to smell. I'm just going to show you these. So you don't have to smell them.
Do you mind opening?
I'll take your word for it. Show them to the city attorney.
Ooh. Fireball? there's also a coffee liqueur and a coconut rum.
I'm just trying to use the new kind of business when there is an options. As they say, it's a land of opportunity. I try to take any opportunity that I could get.
Well, Mr. Jacobs, where are you from?
I'm from India, South India.
How long have you been here in this country?
I've been here for 10 years.
Now, when they did search your business, all they did is pour out the juices.
And I do have the receipt for all these, which was bought by Mr. Willie, and it was all his personal juice bottles that they flushed. And we do have the juice bottles with us. It wouldn't even smell like alcohol. We never washed it, nothing. We just kept it in a black bag, just in case if it helps our case.
And how many times have you been arrested?
4 times.
And that's as a result of these various
Yes.
accusations? I don't have anything further.
May I see those bottles again?
Now, Mr. Jacobs, you have other bottles at the business, correct?
Yes, I do.
Of the same manufacturer?
Yes, same.
And does it come in vodka?
Yes, vodka, everything, every other. These are the things that we use. We are scared to keep this bottle as well in the property because every time they come in, they flush the juice bottles. And these are very expensive. We feel like they'll flush this also. We lose our inventory. So.
Do you have any more questions, Counselor?
Oh, I'm sorry. No, sir, I do not.
Okay. Mr. City Attorney? Mr. Vagovic, did you have any questions?
Yes, sir, very briefly, thank you. Good afternoon, Mr. Jacobs. I represent Tammy Tran. She's your landlord, correct?
Correct.
Does she have any ownership in either Sun and Jack or Social Daytona?
Come again, I'm sorry, what?
Does she have any ownership interest in any of your businesses?
Nope.
Does she participate in any way in the operation of your businesses?
No, she don't.
Okay, thank you, sir. That's all I had. Thank you.
Okay, Mr. City Attorney?
Yes, Mr. Jacob, who was Sunil Kumar?
He's my business partner.
I'm sorry, speak.
He's my business partner.
What does that mean? I mean, how do you define that? What does that mean?
50 and 50, 50. I own 50%, he owns 50%. He's my business partner.
Okay, so he is an owner. You said
Correct.
Okay, I thought you said you were the sole owner. Okay. I have some communication between Mr. Kumar and the city that's going on for some time. Oh, that you can have that one. And I would just like to introduce this to the magistrate, and subsequently I'll bring up our manager that handles this aspect, but this is the communication of what this business is and what they're trying to do. And what I will say though is what I'm handling is not really consistent with what you're describing at the moment.
I'm pretty sure unless and otherwise you visit my private club, which is a social club, you would not understand. how my business operates.
Well, you did say it's for recreation and pleasure, right?
Correct.
Make sure that's heard. And these are the bottles you've been having these since
After
February
September,
Let me finish.
yeah, sure.
After February of 2023, from that point forward, these bottles are the nature. This is an example. The bottles you presented to Magistrate, that's an example of the bottles that you have that we're calling, or the police and others have been calling alcohol, and alcohol and tobacco has been calling alcohol. That's your testimony?
Correct. Did you mention February of 2023?
Yes, since,
We were a hookah lounge till April 4th, 2023.
okay, so you're right. So since April of 2023, is that a sample of what you've been having in your business?
September 17th, as I said earlier, when they executed the first search warrant, they did recover a lot of liquor, beer, unopened bottles of wine, which was displayed on the bar because we used to be a hookah lounge. Sergeant Blower did tell me, you can keep it as long as you don't have a sale. You can keep it for decoration. Just mention it on the bar. It's still there. And they came with the search warrant. They recovered, the ABT recovered those evidences. After that, ever since that, I took the advice from my lawyer not to have the liquor. And we've been established as a business there for almost 1.5 years before we changed to a private club. So we used that opportunity to come around in a different way to keep our business alive. And this is what we've been serving ever since then. And we do have kava, if you're aware about what is kava.
Say that again, I'm sorry.
Kava, kava.
I don't really have any more questions to you. I will present my rebuttal in this time.
So it's your testimony under oath, there was no alcohol on the premises on March 9th.
Correct.
Were you on the premises March 9th?
Yes, I was.
Did you observe the police gathering and examining bottles and what have you?
The police?
Yes.
They handcuffed us. They were doing their search
Did
warrant.
you see them
No.
looking through the bottle?
We did see it in our camera, yes. They were looking for they flipped the place down, the couches. Oh, sorry.
It's fine. And so whatever they smelled, you're testifying under oath, would have been one of these products, but it was not alcohol, and these products are all non-alcoholic.
Correct.
Okay. That's all I have.
Thank you.
In light of that, can I just ask one question specific to your questions? And you're saying that in all of these bottles are mixed, they were mixed with these products that...
We never mixed alcohol in the juice bottles. We don't have to.
So that's untrue?
That wasn't his question.
That's what he
Answer
has.
his question.
Yes. Go on.
Ask your question again.
Can I hear that again? Sorry.
Yes. I said that the testimony is that whatever was mixed in these bottles was this stuff here. They said something was mixed in the bottles. And when I say this stuff, I'm pointing towards the items that you presented as the non-alcoholic items.
There was no alcohol in the juice bottles.
That wasn't what I asked.
I know that is a juice bottle, so I cannot lie to what I know. Whatever you guys flushed is juice. I can assure you that. I have the receipt that I bought from...
Okay, so that's a little clearer for me. So you're saying it was solely juice, nothing else?
Nothing else.
Okay.
So the juice bottles didn't even include these products?
These products are served under the bar. We serve it under the bar. We have a bar. We have a bar set up. They serve it under the bar.
So these products would not have been mixed with any juice
No,
bottles?
they mix the juice with that. They pour this, they pour the juice with that. That's it. And that is what being served in a cup.
So are these products mixed with anything at all?
No, not at all. They are mixed with the juice, what we have, what we carry, cranberry, Sunny D, all those.
Okay, I guess I'm just not understanding something. are these products poured in a cup with any other ingredients?
Correct, yes.
And served to patrons?
Yes,
Okay.
correct.
So, if you had patrons on March 9th drinking Sunny Delight, cranberry juice, whatever, if it was mixed with anything, it was mixed with one of these products.
Correct.
Just so for clarification though, Ross also is saying that none of this stuff was poured in any of those juice bottles.
No,
Okay. So there's nothing other than juice in the juice bottle.
correct.
Okay.
Okay, anything else?
Mr. Jacobs, the 5 bottles that are up there right now, are they all the ones that were at your place that evening, or are there others?
There's more others.
And was there a vodka one?
Yes, there's vodka too.
I don't have anything further.
Mr. Vagovic, any more questions for this gentleman?
No, sir, thank you.
Mr. City Attorney?
I'd like to recall Lieutenant Gurnett.
Okay.
Lieutenant, you heard the testimony regarding the alcohol which you feel you tested and verified was alcohol. What's your response to what was in the bottles? And were you talking about in the bottles, or were you talking about cups of drink?
So when we executed the search warrant in September, we did recover a lot of alcohol. Cases of beer, unopened bottles of various liquors, wines. Yes, some of that was behind the bar on the wall. Some of that was in a locked cabinet under the bar. And a lot of it was in a secured, I would call it like a storage closet that we had to open to recover and remove from the property. If they changed their business model back in April and they didn't open until June, they never removed any of the alcohol. But they also sold alcohol to undercover officers, to include beer back in September. At any time during my search warrants, none of that kind of bottle, brand, anything was recovered in any search warrant. I don't recognize any of it. Don't recognize the labels, don't recognize the brand names, don't recognize any of it. From the September one, January, February, or March. And in the March search warrant, none of those bottles were there under the bar or behind the locked cabinet that they use for securing their liquor under the bar.
Okay, now you spoke of juice bottles,
Yes,
and either by odor or taste,
correct.
your testimony was that you smelled or tasted alcohol. Tell me more about that as relate to this. Did you smell alcohol in those bottles?
Yes, I did.
Did you taste alcohol?
I did not drink
Oh,
that.
Okay, so
I was
you
in
did it,
uniform and I was on duty. I'm not drinking it.
okay, so this was solely from taste,
From smell?
I'm sorry, from smell,
Yes.
but also confirmed by your undercover.
Experience and from the undercover officers that consume the alcohol that they purchased.
And you have the experience of recognizing alcoholic beverages.
Yes, sir.
In fact, you probably have to utilize it even when the odor of an alcoholic beverage with DUI and other stuff over
Yes, sir.
your 21-year career.
Correct.
And so you clearly are confident in that this was an odor of alcohol
Correct.
in those various bottles that you saw.
Yes.
I don't have any other questions.
Did you review any of the 707 reports on the individuals that were arrested on the 9th?
Yes.
And did any of them indicate in them that there was anything with alcohol in it found on the premises?
I don't remember what the affidavit read. I would have to review it.
But you did review it?
Yes. Sergeant Blowers completed this arrest report, and I reviewed it before he submitted it for the system. At no time during any of these search warrants or contacts with anybody related to this business did they mention anything about utilizing that kind of liquid that they would be serving any of their customers.
Non-alcoholic beverage.
Is that what, okay.
I mean, that's what it says on
Okay.
it, I believe.
Is this the
It's, I think,
glasses?
I've got it here, but I don't know that you want to try them?
Yeah, it says that the undercover officers approached the front door, were asked to pay a $50 cover charge, which included alcohol. and hookah to enter the business. Once they paid the funds issued, they paid their entry fee with funds issued to them from the department. They were given access to the business where they went to the bar and they both ordered drinks. They consumed the drinks, the alcoholic. One of them ordered cranberry and vodka and the other orange juice with vodka from the owner, from a co-owner, and his name is Neil Dayukar, which I hope I'm saying it correctly. They both consumed the alcohol and recognized it through their experience. After 20 minutes, both left the business, and then we entered the business to execute the search warrant.
In the execution of the search warrant, was there any notice that there was alcohol on the premises? I recognize the allegation of the sale of alcohol, but when you executed the search warrant, is there any report that indicates that you found alcohol there?
In a supplement, there would be, yes. I completed a supplement later. I don't remember if it was the next night or a couple nights later where I did the supplement based on my review of the video from live and then from what we recovered during the search warrant.
And then the inventory is presented to the judge after you execute a warrant, and it's an inventory and receipt.
Correct.
And does that look like what was toyed with at the?
Yes, that looks like what we recovered.
Okay. And does anywhere on there, and you recovered it, what'd you do with it?
We had to pour it out because it's alcohol and it was open. We couldn't tag it.
Okay. And where does it mention alcohol in any of those?
It doesn't say anything about it being alcohol.
Correct. Are there 1, 2, 3, 4, 5, 6? And no mention of alcohol?
Okay?
No, I mean, I was asking you. Is that correct?
Yeah.
Okay.
How are these items described?
I'm sorry, Judge.
How are they described? What's listed?
They just say Sunny D bottle, orange, cranberry bottle, cranberry, ocean spray cranberry, Sunny D bottle of orange juice, empty containers of garbage, Dole, ruby red, grapefruit.
Okay.
I don't have anything further.
Let me start with that, if I may, or did you want to go up there first? Okay, I will. Okay, no. Did your narrative include that you seized alcohol?
Yes.
Okay. Now, you were monitoring when the undercover went in, right?
Yes.
And you've checked videos even after the fact.
Yes.
And your report says that when you paid a cover charge, it included alcohol. Is that what they told you?
That's
Is that what they said?
I don't recall if that was exactly what was said on the video. But as they went into the business, they went to the bar to pay for the alcohol that they ordered, and their money was not accepted at the bar.
And they ordered alcohol.
Correct.
They didn't order a substitute.
No,
They didn't order Kiva.
no,
They ordered alcohol.
no.
They
They
was-
ordered alcohol, they ordered cranberry and vodka, and they ordered orange juice and vodka.
And they were served what was alcohol from their testimony. I mean, from their report.
From their, what they
Their experience.
observed, yes,
And from what you heard.
Correct.
And understood what's going on.
correct.
Okay.
And am I to understand your testimony, nothing like this was found?
I have never seen those
On the
bottles.
premises?
Ever. No, sir. Not even during the search warrant in March.
I have a picture in my materials. What is that?
Ooh.
It's not a great picture, but I'm just wondering if somebody can identify it for me.
That may be the same picture that Sergeant Blowers was holding up before. I don't know. It may be a lot clearer from him. You can come down, Mr. Blowers.
McAllen, may I see that, please?
Is that the McClellan or something like that? That's a whiskey, I believe.
Okay. Thank you. Have a right to sort. Yeah, Mr. Lambert.
Yeah, that's a little clearer. And when was this photograph taken?
I do not have that currently. I have to look it up. Give me 1 second.
May I see the photo?
Sure. Looks like this is dated January 12, 2024. Make sure you show it to council.
That would be if I remember correctly. Yeah, no, if I remember correctly, that is the alcohol that we found under the DJ booth on the search warrant in January. It was a half full bottle. We had to pour it out.
Okay.
Do you know whether or not that was discussed with or by the owners?
What do you mean?
What you took there?
Was that discussed with them?
Yes.
That we found it under the DJ booth?
No, were they there?
Oh, yes.
Did you talk about this is alcohol?
No,
Did you ask them where it was, what it was for?
no. Under the city ordinance for the after-hours permit, if they're gonna have alcohol on property, they're responsible for what occurs on their property. So if somebody brought in a bottle of alcohol, they're required to ensure it's no longer on property, or that nobody brings it on property.
Does that apply to everybody?
It applies to anybody who has an after-hours permit that's selling alcohol.
And he doesn't have an after-hours permit,
No, he doesn't.
and we're contesting whether or not he sells alcohol.
And let me make it clear, if I may, and this is a legal statement, if I may, Mr. McCallum, if you would look at article, the law that I gave you, 10-2, I believe it's 10-1, I believe it's the definitions. It's 1 or 2, I'm not sure. But in those definitions, it defines an establishment selling alcoholic beverage, and it doesn't have anything to do specifically with whether or not they're licensed. In fact, it includes a bottle club, which isn't even authorized or lawful, is expressly prohibited in the city of Daytona Beach.
Oh, I know what I was going to ask you.
Okay, does anybody else have anything they want to present?
Your search of the building, was all that on Axon?
Yes.
And do you know if the entire building was searched?
Their portion of the building was searched. The other half of that building is a pizza shop. My search warrant did not include that.
And were there any doors that were locked?
No, not to my recollection, no. In the first one there was, in the first search warrant there was. Every
Oh.
time we attempt to search the business or approach the business, they lock the doors, and it takes us 5 minutes or more to get them to come to the door and unlock it. They prevent us from coming in with a legal, lawful search warrant.
So you weren't able to go in and search?
We were,
Oh, I'm
after
sorry.
several minutes of
Yeah.
banging on the door, yelling search warrant.
That would have been recorded as well?
Absolutely. On any officers' axons that were working with us in that execution, their axons would have been on, and every single time we approached, they locked the door. I don't know who would be locking it from the inside, because clearly I'm not inside, but they're locking the doors, preventing us to come in.
Were the patrons, if I may, were the patrons inside?
Yes.
And how do you conclude they were patrons?
They were customers within the business. They weren't employees, to our knowledge.
Okay, and they were utilizing the hookahs or the drinks or whatever, they
There
were
have
in the
been-
business?
Yes, there've been times where there've been active hookahs on tables, there's been alcohol. Sure, I mean,
So on that time it was up, there were patrons in there?
yes.
Okay.
Okay, what is the second case that I have?
It almost could have been consolidated with this one. The only thing different about the second case is the business opened after hours without an after-hour license. And it's only, based on what was cited, it was only cited against the business owner, not against the tenant.
Okay, what is the second case about?
The second case is about selling alcohol or consuming or having it on presence. And all we were asking for in this case was because this is a repeat violation. From January 27th for SMG 012717. On January 9th, you found this business in compliance with a will fine. All we were seeking today is just a recommended fine of $1,000 for repeat violation.
Repeat violation when?
That would have been on the 9th
So
of
this is the
March.
same March 9th
The
event?
same event, yes.
Correct, sir.
Okay, just out of curiosity, following the imposition of the last fine, the property owner commenced eviction proceedings. So what remedial measures does the city contend the property owner has failed to pursue or explore, given the last fine that they were subjected to? In other words, what else does the city expect the property owner to be able to do to rid themselves of an allegedly troublesome tenant beyond commencing eviction proceedings? Because of course, they can't indulge in any self-help.
Yes, sir. This was discussed when this violation was presented, and conversations I had with Ms. Tran back in January. That is when she had stated that she was going to start the eviction proceedings.
And she had not.
And she had not.
And she
did
got
not-
fined
Yes.
for a prior
No.
occurrence.
No, it was a we went in for non-compliance, compliance, will fine. So there was no fine in January.
Okay.
And that is when, through conversations I had with her, I explained that what the situation was. I had conversations with her.
And she got fined in February,
Yes, sir.
and she's commenced eviction proceedings in February.
Yes, sir.
And I'm assuming Mr. Vagovic wouldn't lie to me. So those proceedings are presently pending. He tells me he's awaiting a hearing. He's trying to get a final hearing at which he hopes to get a writ of possession. So if the city's asking me to fine the owner, and I'm supposed to take into consideration any ameliorating circumstances, what has the owner failed to do that warrants fining the owner? Or has she already done everything that can reasonably be expected of her? Don't give me the history lesson. We already fined her for what she did in the past.
Certainly. Ms. Vicalja, we applaud where they are right this moment. However, we were concerned that the order went in place on February 10th, and wasn't until the end of the month, February 28th, that anything was filed. And
But it was still filed before the
The next
event
week.
we're here on now.
That's correct. We agree with that. We're not trying to say anything other than that. We just wanted to make it aware to you, Mr. Vicalja, that it took quite a period of time before.
So in these two cases, what is the relief that's currently being sought against the property owner?
Okay, the inspector indicated as to the second case, a fine of $1,000. And
Okay, that's denied.
okay, and as to the first case, $15,000. That's to both parties
That's because of the March 9th event.
because of the March 9th event.
That's denied.
Okay, as to the
Property owner.
property owner. Okay.
Okay, Mr. Vagovic, I'm denying the fines that the city is looking for from your client.
Yes, sir. Thank
If I
you.
find out that eviction proceeding hasn't run its course, then she might find herself back here.
I understand that, Your Honor. We're going to do our best to get it resolved before we have to come back here and get them out.
Yes, sir. Okay. You're welcome to stay or leave, whatever you want.
Thank you. I'm going to go watch the Masters. Have a great weekend, everyone.
You too, bye. Thank you.
Okay, Mr. City Attorney, let's hear what you have to say. Let's hear like a closing argument or something like that. And I just want to be clear about a few things. As I recall the officer's testimony, these bottles were nowhere to be seen on the March 9th event. Did I hear that correctly?
That's correct. In fact, it was never on any of our events.
And she herself heard conversation about alcohol and her undercover agents commenting about the presence of alcohol.
They ordered alcohol, and they
Ordered alcohol.
and she verified by smell, and they tasted.
But even though they're not here to testify, she was hearing this simultaneously as the events were occurring.
That's her testimony, yes, sir.
All right, go ahead. So explain to me why it is I should be fining these business owners and what evidentiary basis there is.
Yeah, Mr. Vacaljo, and this was presented to you in the prior,
Don't give me a
hearing as
history
well.
lesson.
Yeah, I'm not
March
gonna go
9th,
into-
I don't want to hear anything about history.
Okay, we'll talk going forward. However, this is built on a historic
understand.
event. But where we are as of the March 9th, they,
I not only understand, but those, don't let me, I am mindful of the fact, these people have been here before, they've been found in violation before, they've been fined before, so they're gonna have a hard time explaining they weren't aware of what the laws were, or what the ordinances were, or what the requirements were. So I'll save you that part of your presentation. So let's talk about March 9th.
okay, so the testimony is that the officer went in. There's no reason, there's conversation, whatever that conversation is, about entry that required a cover charge. They paid a cover charge. They got in, they asked for an alcoholic beverage, and they will give them an alcoholic beverage. I know that the respondent testifies that they gave them a mixed beverage from this stuff that they introduced today. However, they asked for an alcoholic beverage. There's never been any indication, not in any documents, not in any conversation, not on the videos expressed, not even in the reports, of anything other than alcohol. They've never suggested or indicated in any way that what they have or what they're doing is anything other than alcohol. The officer testified with the satisfying what would be the criteria for determining whether it's alcohol, and it's a violation of the city code. It's a violation of the state law, but it's also a violation of the city code. And specifically in this situation, they operated this business. They operated this business being told that they couldn't operate this business without having the development orders that were required. Even if they didn't understand it from long-term, from April of 2023, it was reemphasized in February of this month. And in fact, I presented you with the dialogue of here's who we say we are and so forth, but they still don't have what would be required for them to be able to do the operation that they're doing. And so with that being said, they're not what they say they are. They're not a social club, but even more so, no matter what they say they are, they have no lawful authority to be operating any business right now in that facility other than a social club as described by our officer, I don't remember what her title is anymore, but Ms. Askew, as described by Ms. Askew. It's as I said before, it's clearly something where the businesses are complaining, rightfully so. They have a business advantage of all the businesses around them. When they pour out of the businesses started complying with law, everyone's pouring into their business. It's unfortunately, we're limited to economic only, and that's unfortunate because they seem not to be bothered very much by the economic impacts that have affected them through the arrest as well as through our enforcement. However, this is the action that's being taken by every tool that we have through the action of our law enforcement. We recognize there are tools in the criminal, and at some point we'll deal with those when they get to that point in the criminal cases. And so every aspect of what's been happening, what's continued to happen, what's the clear ignoring of the orders and the demands of the city as well as this magistrate, they've been ignored, they've been violated, and because of that, we asked for a fine of $15,000 to be imposed.
All right, are you talking one case, two case, what?
I'm sorry. As to both cases.
So you-
Well, I'm sorry, they're not on both cases. They're only on case number one. So this is only as to case number one.
So is case number 2 involve another $15,000 fine?
Case number, when I say on the agenda, case number 1, SMG 042480, is the only case where we cited the tenant. We did not cite the
I'm
tenant
done with
in the
the
second
owner.
case.
I'm done with the owner on
Yes.
both cases.
That's correct.
The only thing left to be resolved is the tenant on case 1.
That's correct.
Okay. Did I understand someone to say somewhere along the way that as a social club, they really have no opening or closing hours?
Right, if they were a social club and they weren't serving alcohol or that
They
allegation.
could be open or closed whenever they wanted.
Yeah, they open and close whenever they want. They have
If they're serving alcohol, then they got to comply with the,
the state law as well as our local ordinance.
okay, all right. Counselor?
Judge, relate back to a definition of insanity, doing the same thing over and over again, thinking the result's going to be different. They've been arrested 4 times. To me, the biggest problem with this, I know that formal rules of evidence don't apply, but due process does apply, and the issue of the willful destruction of evidence. So we have, I mean, law enforcement has been going after them relentlessly with regard to this. What they may want the building for, I have no idea, but they've been going after them constantly. And with that, one would think they would want to preserve the evidence so that they would actually have the proof. The spoliation applies both in civil cases and in criminal cases, and now there's nothing but an officer's word for us to go back on. When you saw in the, well, you didn't, but you heard of the bottles. So there were numerous bottles. It's nothing to preserve them, is put them in a refrigerator. They have refrigerators at the police department. And that way it would be able to back up their defense. But now they don't. Now they just have to rely on an officer saying, I smelled alcohol.
Okay, Mr. City Attorney, what's your response to the spoliation argument?
It's not spoliation. The law is real clear, not only in our code, but also in the state law. It's a routine thing that alcoholic beverages are destroyed. That's not a new thing. That's a routine thing. And the law has made it real clear that the identification and the proof of alcohol has been by someone with actual knowledge of an alcoholic beverage, what they smell like, what it tastes like, to be able to say this was an alcoholic beverage. That's been sufficient. It's been sufficient, and it's been sufficient in the state statute under Chapter 562, probably 14, but I'd have to look. I don't know if it's 14, maybe 12. But it's under Chapter 562 over the floor of the statute, and we pretty much reflect that in our ordinance as well under the section that I referenced. I believe it's 10-3. So it's not a spoliation issue when we're able to present the evidence as required and with it's specifically expressing it as the sufficiency of evidence under the law to make that determination by smell and observation. In many occasions,
Okay.
we're drinking.
Forgive me, I'm no criminal defense attorney. Are you telling me there are criminal evidentiary rules, statutes, or cases that say an officer's testimony regarding the presence of alcohol suffices to establish its existence?
Yes, I am. And if we have the statute, I'll pull it in. I'm sure I can show it to you. Yes, there are. And as I said, in addition to that, it's clearly established in our code. And the main thing is that we have circumstances where someone drinking from a cup, you're not going to try and save alcohol in a cup. You're going to dump it and throw the cup away. Someone, unlawful use, possession of alcohol is not preserved by hanging on to previously open alcoholic beverages.
Judge, I would agree that statute exists, and its application is primarily for underage kids with a red cup. The officer just goes up, smells it, and gives them a citation for it. The magnitude of this case, one would think they would want to, I mean, there's so much there that they're saying is alcohol in these juice bottles that they would want to preserve it.
Okay, well, the two of you combined are catching a fish out of water here because you two know more about what you're talking about than I do. I'm inclined to accept the officer's testimony. The officer testified that she had undercover officers, experienced officers, talking about buying alcohol, being told they're going to be sold alcohol, tasting alcohol, having alcohol, holding alcohol, and I'm not inclined to dismiss that lightly. And I also heard specific testimony that none of these products were seen on March 9th when this took place. Now, in response to that, I've got your client saying, oh, this is all we sell. We don't sell anything but this. Okay, well, that's diametrically opposed to the sworn testimony of the officers that I've heard, and especially coupled with the fact that they specifically testified none of these products were present. Now, you're bringing up spoliation, okay? All right, well, I'm probably just familiar enough with spoliation on the civil side to be dangerous. So,
Can I just speak to that 1 second? And I know you want to continue. I think the ultimate argument from Mr. Lambert, even though he used the word spoliation, is more an argument of the weight, saying it would make more sense. It's a weight of evidence, not the absence of evidence, because evidentially, we're saying statutorily that evidence is sufficient.
and I know enough about spoliation to know that if you voluntarily destroyed evidence, there's a presumption against you that you did so for a reason. Now, that admittedly is my ignorance from nothing more than having dealt with that on the civil side. So, why don't both of you send me something within the next 10 days? And I specifically, and I'm just going to tell you where I'm coming from. I'm inclined to rule for the city. Another issue's been brought up about destruction of evidence. Like I said, I know enough about spoliation to know that it might be an issue, so I'll hear it. So you can provide me whatever authorities you want that say, hey, dumb special magistrate that knows nothing about law enforcement, this is the way it's typically done. And your instincts regarding the officers are absolutely correct. And coupled with these rules that I'm providing you, you're going to be plenty satisfied that we've satisfied our burden of proof to establish that there was a violation here just as we've alleged. And he can sit there and say, I don't care what he says. He destroyed the evidence. They shouldn't be allowed to get away with destroying the evidence and then leaving you with nothing but testimony as to what happened, coupled with, you know, the law says there's kind of a presumption against the guy that destroys the evidence. I'm not trying to make this more complicated than it is. It's obviously a thorny issue. I just want to get it right.
Understand.
So, within 10 days, both of you send me whatever you want me to consider in the way of a closing argument, and then I'll make the decision. If I find against the respondent, I'll be fining him $15,000. If I don't find against him, then I'll be doing whatever it is I'm doing. I don't know what that might be. But you've just brought up a topic or two that just causes me a little bit of concern that I want a little more information on before I go making a decision that I consider to be important to everybody involved. 10-4?
Sure, very good.
10 days.
Mr.
What you got
Magistrate?
to say? An officer, and this is directed to the respondents too. I mean, no disrespect to anybody here. I hear y'all's testimony. There's a legal question that's been raised here, and I'm wanting additional information on that.
I'm sorry, sir. I apologize.
No, I was just telling everybody, please don't be, I hope I haven't insulted anybody here. I'm looking for a little bit of information on legal matters that have been broached here that I am unfamiliar with.
I can answer your question partially, I think.
Go for it.
Our directives in the police department do not allow me to keep the
You already
open
explained
alcohol.
this.
Right, so I assume that was, and I don't know if that's gonna be enough or not, but that's the reason why I did not keep that alcohol.
I
or those
understand
bottles,
that.
And we don't have a refrigerator to keep that. That's not what it's for.
I heard you.
Okay.
I understand. And this is why I'm going out of my way to anticipatorily apologize if I've offended anybody. He's telling me this is how you weigh the evidence in this context. I go, okay, never been involved in it. Take your word for it. He's telling me, well, yeah, but you know, their policy is to not keep the evidence, but that policy violates principles of spoliation of evidence. And if you're persuaded that they violated spoliation of evidence, notwithstanding their policies, then there's a certain presumption that arises that the reason they're pouring it all out is because they know there's no proof of what they're claiming. I'm not passing judgment on anybody's word right now. I'm asking him to educate me on the weight of the testimony that the city's presented. I'm asking him to educate me on a legal issue he's raised that I want to hear more about before I make my decision. 10-4?
sir.
One thing, if Mr. Lambert doesn't mind, I'd like to just, since I do have a copy of the statutory provision, I'd like to present that to you, even though we'll still go and prepare as you're instructed. And I just showed this to Mr. Lambert as well.
You know what? Just send me everything at the same time, okay? Okay, just everybody send me everything at the same time.
Do we want to continue this to get the order?
No.
At a later date? Nothing, just do nothing till later?
There's nothing for anyone to do but me.
Okay.
I guess I'll instruct, and whatever my decision will be, just to let you people know, I presume I'll be communicating it to the secretary, and the secretary will be generating the standard order, regardless of what the outcome may be. So that'll be the process.
Thank you.
And I thank all of you for being patient with me. Okay, Kim, I think I've signed all your stuff. Oh, and with that, we're adjourned.